Hey, Ann, if you want to turn on your camera, probably keep the audio off because it'll bleed into each other. So I usually when you're talking, when you talk, hi Ann. So just to let you know. So when you talk, I put my mic on, I mute my mic, and vice versa because there'll be feedback sometimes. There's a loop. And we'll have you introduce yourself once we start. Okay, guys. So um to repeat what my intent was, please send out, just like Angela did. Ronald, well, actually, Ronald didn't even say where he's from yet. I know where Ronald's from, but guys, send out your agency to all attendees. Ross Kelly, do me a favor, resend it out to all attendees because nobody can see it except us if it says all panelists. So do me a favor, resend it out to, what's up, Ron? So send it to all attendees. Fixing up your lights, Ann? All right. All right, guys, come on. Let's see where you guys are from. So Ron, Michael, what's up, Michael? I'm glad to have you here. Unified PD, Utah, the Las Vegas Metro of Salt Lake City. Is that something that can compare? You know, Catherine, one of my star students, right? Catherine, Phoenix PD, one of my star students. Hey, Catherine, are you going to be? You're not going to be at my. Are you going to be at my surprise Arizona class? Remind me, or I don't think so, right? I know that sucks. All right. Do I need to call the chief and fix this? Do I need to call? Give me the phone number. I'm calling the chief right now. Okay. There's nothing more important than getting you to that search and seizure class. There's no riots. There's no corona anymore. Get to that class. All right, guys. Okay. It is that time. Okay. It is that time. It's high noon. I'm very excited about today. I'm with my co-instructor, Ann Kelleher, the best. I mean, no, I'm serious. I learned. I'm ready to learn today, but I'm going to take the lead today because Ann is almost like a mime, right? It's like a mime with no sounds, right? Okay, so let's get started. So as I introduce the class and kind of go over some disclaimers, please get those questions ready, okay? Get those questions ready. And I'm also going to ask that for the people who are on this webinar, if you have not shared your agency, whether you're a prosecutor, whether you're a police officer, a defense attorney, please go to the other class. No, I'm joking. Please share your agency. Everybody wants to know. We love seeing who's here. Okay, so let's start. The first thing I want to remind you is that we are teaching search and seizure next week. Okay, we are teaching search and seizure next week. And Ann's taking the lead on this class. Okay, and I'm telling you, you have an opportunity to take our training without physically having to travel. It's going to save your agency money. You don't have to, a lot of our officers are doing it from in their PJs from their home. It is your opportunity to take our training before we start going back to live training. And you're going to have to travel somewhere to meet up and take our training. So we'll still try to do some online training in the future, but we have no guarantees. Ann and I are booked up for the next year, teaching essentially every single week in another state. So this is your chance. And I just want to remind you of that. It's worth it. It's absolutely worth it. Okay. So let's continue. All right. Just remember to, again, I have to say, I see a lot of people who still have not shared their agency. So please, I encourage you, we want to know where you're from. Select all panelists and all attendees in order for everybody to see it. And also when you ask a question, send it to all panelists and all attendees. So welcome to Search and Seizure Saturdays. I'm glad you're here. Let me first introduce myself, and I should have put up a thing for Ann. This was kind of like last minute, but it's okay. So my name is Anthony Bandiero. I'm an attorney and senior legal instructor at Blue to Gold Law Enforcement Training. I, along with Ann, this is what we do for a living. We have the honor and the privilege to train police officers from around the nation. I have some police experience. I did about 12 years as a trooper sergeant, mostly in Vegas, and also with a smaller department up north. I have nothing but good things to say about my experience. I did everything I wanted to do, but I have to say that this is my passion. So I retired early, and I'm chasing my dream right now, which is teaching officers search and seizure. That's a little bit about me. And I'm going to turn off my mic for a second. Introduce yourself.
There we go. I turned on my mic. So welcome you guys all for joining us this fine Saturday. As Anthony mentioned, my name is Ann Kelleher. I am also an instructor with Blue to Gold. I also have background in both law enforcement and as in law enforcement, not only on patrol. I work for a rural sheriff's office here in north central Idaho, where I'm coming to you from today, the Clearwater County Sheriff's Office. I was there for 12 years. Working my way up, patrol sergeant there, ran a canine, emergency response, just had a lot of opportunities while I was there. I took kind of my interest in the law, especially this area of search and seizure law, onto kind of its next logical step, which was, law school. And, but with the goal of still putting people in jail, right? I still wanted to put people in jail. I just didn't want to have to deal with them in the backseat of my patrol car anymore. So I became a prosecuting attorney, both first with a tribe, and then as a felony prosecutor. So I've seen a lot of these issues from both ends, both from on the street, trying to make those decisions quickly, as well as the prosecutor now reviewing those decisions that y'all are making and trying to figure out, okay, how are we going to defend this in court and get a good result for you and the community. So that's a little bit about me. You can go to the website, bluetogold.com, and read more about us and our bios there. And I will give it up to Anthony again. So welcome again. Thanks for all for.
So one thing we've been so busy with everything. I forgot to tell you that I bought a piece of land in Idaho to build a house on. So I'm going to because Ann is in Idaho, I'm in Washington. So I'm going to be a Idahoan sometime down the road. So so I'm very excited about that. Yep, northern Idaho, and Idaho is definitely more my style. All right. So I want to also share with you these two books. These two books, I believe, are vital for your education. They move the ball forward. Okay, they're written for you, and I'm going to give an example how the book is used in this class. But they're written for you. The Search and Seizure Survival Guide is used by thousands of agencies around the country. The Bulletproof Report Writing book also helps you to articulate those things needed to win your cases in court and also successfully defend yourself from lawsuits, which is very important right now. You got to defend your defense from getting sued and so forth starts at obviously it starts during the activity, be constitutional, but it also matters how you articulate things. I have another book coming out that's a pocket guide for reasonable suspicion and PC. I think you're going to love it. Couple weeks, and that's it. Okay. Also, there's the other thing I want to share with you is that report writing book is going to be used in a new class that we're launching, Bulletproof Report Writing, and Ann and I will be teaching that coming up. So it's going to be very exciting. Okay, disclaimers, right? Thanks, Angela. Appreciate it. Disclaimers: laws and agency SOPs may be more restrictive. Okay. We're just going to talk about the Fourth Amendment and the national standard. The good news is that 90%, if not more, of what we teach is the same in every state. But sometimes states can be more particular about certain things, running dogs around cars, whether or not you need reasonable suspicion to seek consent to search, those type of things, right? Thanks, Jonathan. And these, by the way, we had a huge backlog with these books, but now we're all caught up. So if you order them, they get shipped directly from us, and we are up to date. If you have any doubts about the legality of your actions, push up the chain. And finally, this course, this training is legal education, not legal advice. Ann and I are not giving you legal advice. If you are unsure about something or you need legal advice, you gotta reach out to your prosecutor or legal advisor. We're just sharing with you our opinions. And, that's what it's worth. It's our opinion about where we think the law is today. And and when you ask those questions, and I hope that you are getting ready to ask your questions, I have a case I want to talk about just in case you have no questions yet, or you're just not ready to ask a question. But we're going to give you our opinion about what we think the courts are going to be looking for. It's extremely valuable. But remember, if you need research advice, either contact your legal advisor or call us, and maybe you can retain us for expert advice and so forth. All right, your cert will be here. So download your cert, and you'll see other webinars too that we're launching. And I'm glad you're here. It's gonna be fun. All right. So here's how I want to proceed. Again, your questions take precedence over what I have in store for you. I have one case. I think it's valuable, and so forth. So on the books, did you say to order them from you instead of Amazon? I have a Kindle, but yes, order them from us. Number one, it actually helps us more, to be honest with you. Bezos takes most of the money for his G3, his many G3s. So it helps our company, especially, it just helps us, and we deliver them faster. And sometimes we throw in a little extra stuff in the package. So Ronald, there you go. Order them from us. Okay, I'm trying to get my own G3. I'm sure Bezos has something way bigger than a G3. I mean, he's a Boeing guy. He's a Boeing guy. I'm going to be a prop. I'm going to be a single propeller prop guy. All right. So here is a case that I just read, and I said, there's some teaching points here. Okay, the case is U.S. versus Michael Torres. It's out of the Third Circuit. It's out of Pennsylvania. It was just decided June 5th, 2020. So this is hot off the presses. The ink is still wet. The topics are face-to-face tipsters, right? Getting tips from anonymous, quasi-anonymous people that just tell you that there's criminal activity, but then they leave. And also this idea of pointing guns at suspects during a investigative detention, and also using handcuffs. So here is the area, or this call involves this area, okay? So this is in York, Pennsylvania. It's near a university. This is a high crime area. So the court did establish that there was a lot of shootings, auto burgs and so forth, recent activity in this general vicinity. So here's what happened. Officer Pickle, okay, he's patrolling the area, and he gets flagged down by a guy in a passenger car that's on the side of this road. It's about 6 p.m. on Halloween night. So the citizen tells the cop that the guy walking on the bridge, on the sidewalk where that arrow is, just shot 2 rounds into an abandoned building. Okay, now the cop did not hear any shots fired and so forth. He's just patrolling. But I think what the guy was doing, he was watching the guy, and he was getting ready. He was trying to call 911, but then the cop came around the corner. So without he confirmed. He says, that guy right there just fired 2 shots. He says, yes, that guy right there. So the officer then leaves the guy, and that guy takes off. No name, no address, no phone number, no license plate. The officer can describe the tipster and the car he's driving, but that's about it. The officer then starts calling it in, get the cavalry coming, and he says, you know what? It's just not. This can't wait. The reason it can't wait is because in his experience, there's a lot of side streets, and he can go down the bridge area, and he can kind of get away before the cavalry shows up. So he decides to take action now. He gets out of his car. He unholsters his gun. He points his gun. He tells the guy to, get down on his knees. He handcuffs him. And then he pats him down and finds a firearm. So here are the legal questions. There's 2 legal questions that I want to address in this class. Number 1, could the officer act on this anonymous tip? I mean, is this even something can we even detain this guy? Jamie says yes. What do you guys think? Okay. Good. Angela's like, absolutely, right? Almost like dereliction of duty. Wouldn't it be almost like dereliction of duty if you're like letting this guy go? So you're all saying yes, but here is what the defendant is saying. Michael is saying, look, this is an anonymous tip. And there is no corroboration of inside, it's just a blatant accusation that I'm doing something illegal. So is this truly a true anonymous tip? Yes or no? Is this a true anonymous tip? Yes or no? Jamie says no. No. Okay, that's correct. That's correct. That's one of the lessons here. Okay, this is not a true anonymous tip. Okay, so when I talk about these issues, here is an example of how the book is used. Okay, I talk about detentions based off anonymous tips. You may make an investigative detention based on anonymous tip if the information has some indicia of reliability, and where appropriate, you corroborated the tip. Okay, so that's really fundamentally what these tips, you're looking for reliability. Is this something that that's reliable and so forth? And this is not a good example of a truly anonymous tip. A truly anonymous tip is your stereotypical letter that goes to the, or the email, I should say, right? That goes to the tip line and is sent from a web page that does not track you. The department promises that they will not keep your IP address and emails required and name. They will just take your anonymous tip and they'll investigate. Okay, that's correct. So John says it's face-to-face, and that is exactly correct. Okay, this is not a true anonymous tip. Okay, so here's some of the language from the court case. Reasonable suspicion requires only a particularized and objective basis for suspecting criminal activity based on the totality of the circumstances, right? So there's no one factor. And that's one thing about my book. My book is giving you factors in evaluating things. But remember, many of these tests are ultimately based off of totality of the circumstances. I'm just trying to point you in the right direction about what things the courts look for, because courts love tests. They love factor tests. And so do cops, because it's almost like reading from a menu. Oh, I had that, and so forth. So we afford significant deference to law enforcement officers' determination of reasonable suspicion. The reason I'm throwing that in there, okay, is because that is another reason to articulate the hell out of your reports. The courts have to give you some deference about what you're seeing out there. A judge, prosecutor, defense attorney, okay, is in the comfort of their office, leather-bound books, mahogany, what a smell, okay? And they have all day to try to take apart your case. You got a few seconds to decide what you're going to do. They got to give you deference. You're the one on the street. You're the one making the decision. But when it comes to your report and your testimony on the stand, let's articulate, okay? Let's make sure we got our act together. That's part of this. Okay. So here, but only, okay, good. Because Officer Pickle acted on an informant's tip, we must decide whether the tip was reliable. In doing so, we consider some of these following factors, okay? The information was provided to the police in person, right? That's what John said. That is going to allow you to evaluate their veracity. In other words, that's a fancy word for truthfulness. Okay? They look like they're being truthful. They don't look like they're being shady. They look like they're concerned, like this is something that is real. And you also are able to maybe find conflicts. They're not going up to you and say, hey, you know what? My ex-boyfriend has a gun. Go get his ass. That's a conflict there. We're gonna be hesitant on running with that. We want to know why. Right? John, resend it out to everybody. In fact, resend it out to everybody, because that's a very good point. Number 2, the informant could be held responsible if he lied. Now, this is a factor that that the defense is saying, you know what? You can't, you have no ID, you have no phone number, you have no license plate. The court actually said, push comes to shove, the officer could have tracked him down. Thanks, John. I don't know if I buy it, but it's possible, right? I don't know what kind of town York, Pennsylvania is not a small place, right? I'm not sure if that's Mayberry, probably, but not in New York City. So, but the point here is that if you did expend, a lot of police resources, I guess you could track this guy down. He was very distinctive. He had a salt and pepper beard and got a good look at him, and he knew what kind of car he was driving and so forth. But okay, actually, Ronald brings up another good point. The officer actually thought that the tip was captured on his body cam, but it wasn't. It malfunctioned or wasn't turned on. He thought it was turned on. So that was one of the things that the officer thought, but at the end of the day, it wasn't captured on the body cam. If it was captured on the body cam, it's going to help you. Now, what I'm trying to say here too is, don't think you have to be able to identify this guy in order to roll with anonymous tips. Well, when I say anonymous tips, with is bystander tips, right? You don't have to. It's just one factor, okay? It's just one factor of many. It's important if you can. And one of the reasons I bring that up too is because a lot of people will call 911 and say, hey, there's a reckless driver, this and that. Those calls are recorded. You cannot hide your caller ID from 911, enhanced 911 systems and so forth. And the U.S. Supreme Court acknowledged that that was a factor in reliability, because push comes to shove, you could actually trace that call and get subscriber info and maybe charge a person with a false report. 3, info not available to the general public. This is, they're saying that, hey, look, does this person know things that are not knowable to the general public? I don't think we have this here, because he's not saying something to the officer that would not, he's just accusing this, he's basically accusing the guy of shooting at a building, but that is also the same type of flavor of, hey, that guy has a gun. That in itself is not inside, that's just an accusation. There is no corroboration of that. Now, if you saw a bulge consistent with a handgun and so forth, that might be different, but this is going to hurt us a little bit here. Contemporaneous. The court is saying, is it happening here and now? And it is. Okay. He's telling you, hey, this guy was just shooting at that building. And final I say collaboration. It's supposed to be cooperation. Ian, isn't collaboration a little different? Hey, tomatoes. I don't know, but that's not the first time I've used that word instead of cooperation. But we're looking for cooperation. Did you cooperate? Was there again something inside information? Okay. Our agency uses mics worn by deputies and patrol units, has continuous auto recordings. Are you saying that your whole entire shift is recorded on audio? Your entire shift? I have to know the answer on this one, because I can never work for your agency. I mean, I can't. I say some stuff that I make jokes. I can't. That's a no joke agency right there. Not horrible jokes, but I'm just Yeah. I mean, the bathroom. Oh, I see. Encounters. Phew. Woo. And I was scared too. I thought this was no bathroom breaks for these guys. That's embarrassing. All right. Okay. So here the tipper's reliable. Face-to-face tipster. The tipster waved the cop down, and that's kind of like it's what the court is saying, that is giving an indicia of reliability that, hey, he is proactively trying to stop the cop. It's possible to track down the tipster if he lied. I'm not sure if I buy it, but I'll right. And adamantly, yep. The tipster witnessed the crime. There's this excited utterance issue where he is under the stress of the moment, and that is also an indicia of reliability. That people under stress and witnessing crimes firsthand, that shows that they don't have time to make up some BS lie. High crime area, and then armed suspect. Right? Don't forget. Right? Don't forget that the U.S. Supreme Court has implied, at least in Florida versus JL, that when you're dealing with tipsters who are, saying that there's a public safety risk, that is always going to lend in favor. It's going to help. Doesn't mean it's going to be 100%, but it's going to help. Ronald says, would the tipster's demeanor be taken into account? Yes, it has to be taken into account by you. If the tipster was scared as compared to calm, make him more believable. That's exactly right. You want to add anything, Ann, or are you good? Yeah, go ahead.
Yeah, and that's exactly what happened here is the officer. And one of the things I just kind of want to go just really quickly back to the reasonable suspicion, because reasonable suspicion, the court can only give deference to officers who adequately articulate how they concluded that that was suspicious. So you need to be able to you need to make sure you throw in those inferences that you draw. And I think that's what really ties this case together. Is the court goes in its summary, talks very much about all the things the officers did to describe the area itself. And I mean, really the date, Halloween, 6 p.m. The kids are about to hit the street. It's starting to get dark. Now you have that safety issue. But also, even though it wasn't caught on video, the officer and the court even mentioned this several times in the case. This description of adamant, that the tipster was adamant that guy had a gun and adamant that he'd fired the gun. So that type of demeanor really did lend to the officer being able to describe how they concluded it was a reliable tipster, and then the court putting themselves in the officer's shoes to also be able to reach that same conclusion. So it's key, it's critical when you're putting together the pieces of reasonable suspicion that you articulate how you concluded that those actions were reasonable. You can't just throw out reasonable suspicion. That's a conclusion. You always have to describe how you reach that conclusion. So back to you.
Yeah, couldn't agree more. And also this book, right? And Angela, you probably saw this in the back. You got this book too. Is I'm trying to help cops with those factors. I'm trying with constructive possession, high crime area, patting down people, armed and dangerous. I'm trying to let you know that there's a bunch of things that I call them. There are things hidden in plain sight. There are things hidden in plain sight. So it's all about articulation. Well, I guess what I'm trying to say is somebody that's brand new off the, out of the academy, maybe 2 years on the job, versus somebody with 10 years on the job, they have the exact same encounter, but the veteran is able to articulate a pat down and reasonable suspicion and PC, and the rookie is not. But the rookie, if we got to get those rookies up to that articulation ability quick, because that's the name of the game in 2020. And the same facts are there, but they're just hidden in plain sight. Okay, outcome. Under the totality of circumstances, this tip was reliable. So, next question. Under these circumstances, is pointing a gun and handcuffing the suspect an arrest requiring probable cause? Because that is his argument, okay? His argument is that, all right, let's say it was a detention. But you arrested me. A reasonable person under those circumstances would not believe that you're just detaining me. It would be a full-blown arrest. Now, if it's a full-blown arrest, then the gun that you found is tainted. Now, I talk about this issue in my in this advanced search and seizure class, and I have actually a golden rule for it, which is basically the more serious the crime, the more reasonable your actions are likely to be viewed. This is an example of that, right? When you're dealing with officer safety issues and public risk, you'll get to do more things and have some more leeway than if you were just dealing with the candy bar thief, right? So here's an example of the book, right? Generally, if you handcuff a suspect, point a firearm, or use force during an investigative detention, it will likely be deemed an arrest requiring probable cause. Exceptions exist, but you need to have legitimate reasons. If you make a reasonable suspicion stop on a suspect you believe is about to pull a gun on you, then of course you get to point your firearm on them and conduct a pat down. It's like a felony stop, correct? Right? So this comes up sometimes, and don't be fooled by this argument. Don't be fooled that just because you point to the gun that it's an automatic arrest, but there are some factors in place. You got to articulate why it was reasonable. If it was unreasonable, then it will be an arrest, most likely. So here's the court, okay? To begin, there is no per se rule that pointing guns at people or handcuffing them constitutes an arrest. Terry recognized that when officers are investigating a suspect who the officers reasonably believe is armed and presently dangerous to the officers or to others, it would be clearly unreasonable to deny the officers the power to take necessary measures to determine whether the person is in fact carrying a weapon and to neutralize the threat of physical harm. Let's neutralize that threat. Okay, so Officer Pickle received a tip that Torres, just moments before, had discharged a firearm in a high crime area. A brief encounter with police ensued. Only 35 seconds elapsed between the time when Officer Pickle ordered Torres to stop and when police secured Torres' firearm. Thus, the seizure was an investigatory stop, not an arrest. Not an arrest. And if you have anything to add, Ann, just go like with the finger, you add something? All right. So, outcome. Pointing firearm and using handcuffs was a detention, not an arrest. Therefore, no fruit of the poisonous tree issue. The handgun is coming in. 15-year sentence upheld. Holy shit. 15 years minimum. Whoa, Torres, man, you were a bad dude. They didn't like you, man. Whoa. So next time, if for Torres, okay, with people in Torres's position, I have some sound advice. Okay, please keep the gun to yourself. It's those 2 shots got you 15 years, my man. So you might thought it was funny at the time, but who's laughing now, right? All right. Guys, now let's hand it over to you, okay? Let's hand it over to you. We got to have some questions or some clarifications. Let's get some hypotheticals going. Let's get, hey, you know what? What about this type of situation? So work it up. Let's see your questions. Any search and seizure related topic, Fifth Amendment related topic. Okay, what kind of skin cream Ann uses to keep so beautiful? Whatever you want, okay? Let's ask. Okay, what kind of skin cream I use? Do you want to know what I'm using? Egyptian Magic. All right. Egyptian Magic, look it up. It's Costco, baby. Okay, and while if you have no questions, that's fine too. But usually you guys are typing, so I want to wait for a few minutes. Okay, so remember too, guys. Okay, here we go. Finally, on the book, the gospel here. I like to refer the gospel. Corinthians, Anthony Bandieroins, page 112, chapter 3. Okay. Let's see. So on page 112 of your search, it states that. Sorry, Chia, if I embarrass the blue to gold family. Chia works for us, by the way. She's She's our training coordinator. So sorry, Chief, I embarrassed the Search Seizure family. All right. It states if PC exists to search a vehicle, you can search all containers inside the vehicle that conceal the object of the search. To be clear, this also includes searching all occupants if you believe they may be concealing the object of your search. For instance, during a traffic stop, you have fresh odor of marijuana emanating from the vehicle, but no passengers admit to it. This is $1 million question. And do you want me to go first, or you want to, this is your cup of tea, isn't it? You love this question. Go for it.
So I think you set it up in the premise of your question, right? Is we need to look at, because remember, the ultimate question is whether your actions are going to be reasonable under the circumstances. And we know that reasonable expectation of privacy, as identified by the court, there's a hierarchy of it, right? There's certain things that the courts protect differently than others. We know that cars are kind of down lower on this reasonable expectation of privacy pyramid because they're highly visible, highly mobile, and highly regulated. So that's what gets you the cars and their containers. But remember, people are not containers. And anytime, even with cars, in order to do a probable cause search of anything without a warrant, the courts have consistently said you need to have both probable cause and some showing of exigency. With vehicles, the showing of exigency isn't high. You just have to be able to show that it's readily mobile, right? So what exigency exists that would, first of all, you have probable cause to believe that every single person in that car could have evidence on them, right? So that's the first question, is do you have probable cause to believe each individual person? So you have to make an individualized determination of probable cause for each person you're planning on searching. And then what exigency is there that if you did not search them right then without a warrant, you would lose that evidence. Okay, so people are going to be protected differently than the cars and their containers. So before you just start searching people that are in that car simply because you didn't find the dope in the car, right? You need to look for something else. This is my serious recommendation to you all. And I know that this blows everybody's mind and it's usually a big mic drop moment, but right, think about the times the courts have actually said you can search people, right, without a warrant. You can search them incident to arrest. You can search them if you have plain feel, like you're already doing a pat and you immediately identifying something as evidence in contraband. Now you can reach in their pockets to remove it because of the exigency involved there, right? So where on this probable cause, this reasonable suspicion standard are searching people going to be? And I am suggesting that it is going to be higher, significantly higher than just the containers in the car. So think about, before you just start emptying pockets, what evidence do you have that suggests that those people actually have that level of probable cause of dope in their pockets or on their person? Is it just because you couldn't find the dope in the car, or is it because they are demonstrating some other indicia, like the green tongue, the bloodshot eyes, the slow responses, right? Something else. They appear to be the place where the odor is emanating, right? What leads you to believe that that person then has the dope on them? So higher standard than just the vehicle itself. Okay.
Sorry. First, so Angel, and I'm gonna restart. I'm gonna restart with the most important thing that I said. I can't agree with Ann more. She hit out of the park. We're on the same page of this. So here's my little 2 cents, okay? So first of all, this issue comes up constantly around the country. Every single class, people are asking. In fact, I'm addressing this particular issue because it's so important and it's so common. Next Friday at 9 a.m. Okay, so get on that webinar. The webinar is called Searching Cars and Occupants. Next Friday, 9 a.m. It's actually my most requested webinar by far, okay? Because you're asking such a good question. Now, so we know from 1947, I'm gonna add a few more details and flavor onto this, just my own kind of 2 cents too. We know from 1947, the U.S. Supreme Court has said in a case called DeRye that having probable cause for the vehicle does not give you probable cause for passengers. So it's clearly established at that point. The next issue that I teach cops is simply this, okay? The next issue is this. What would you tell the judge, okay? If you had a judge on scene and you had to get the judge's permission to search this particular person, and the judge says, okay, Anthony, before you search him, tell me why you think he has contraband on his person. And just like Ann said, the dog, let's say, the dog alerted near where he was sitting. There was contraband found under his seat. He has a drug history. He's nervous, guilty mind type stuff. Okay. And if you think the judge would say, you know what, I think you do have probable cause, then the next question is under what constitutional principle do you search him? Because what we teach is crew. Anytime you do something that implicates the Fourth Amendment, you need consent from somebody who would give it, a recognized exception, or a warrant. Okay, we don't have consent. We don't have a warrant. What's our recognized exceptions? Generally speaking, there are 3, okay, in this area. Number 1 is exigency. Who said it? John Hill, but only said it to me. John said, I think he meant to send it to everybody. John said the person could walk away for exigency. There usually is no time to go run to the courthouse, to go get paper, to go search this guy's pockets for weed. There is no time in the vast majority of cases. So you may have exigency. Also, you may have an arrest. But Anthony, we searched him first and then we arrested him. The question is do you have probable cause to arrest? Even if it has to be, the search incident to arrest has to be contemporaneous, which means right before or right after, essentially. The courts do not care that it came right before, as long as the evidence you found did not give you the reason to. You have to have the PC before the search. And finally is what's called a non-custodial arrest. That is not recognized in every state, okay? But some court cases, like Colorado, has a case on point that says if you have probable cause for a passenger that they have contraband on their person, you can make a non-custodial arrest, search them for that evidence, cite and release them. So John says, what happens if you search the car but nothing is found? Would it then be more reasonable that the evidence be left on the passengers? Yes, it's more reasonable. I'm not saying it's automatic, though. We can't use that word automatic. I would have to have facts, right? What are you going to tell the judge for that PC? Now, guys, this is where the book comes in. And wait till you see. This book is designed to teach you how to write reports. But wait till you see the RS. I'm calling it the RS and PC pocket guide. Okay, because it's going to be like a spiral notebook, and it's going to have thousands of things by category: trafficking narcotics, fraud, possession of stolen property, searching cars, exigency, and then you're going to be able to look in that. And it's just going to give you some ideas about some of the things that you are seeing hidden in plain sight, right? But part of this book, and a lot of these factors are in this book too, but is a current drug user. Okay, why do you believe he's a current drug user? There's tons of factors that can come into play. Very good question, and that's essentially what the answer is. Talk about some wordy answers, huh? Man, you put two lawyers on a webinar, they'll get their money's worth, huh? And Ann, do you agree with what the points that my other additions to? Do you agree with that? Those 3 factors. Yeah. Okay. What else, guys? That's a great question. What else you got? If they volunteer their ID, you can sometimes smell the residue on their ID. That's pretty good. That's cool. So Anna's saying, I would be super careful with the non-custodial search incident to arrest, cite and release. But I think it still goes back to exigency, don't you, Ann? I think at the end of the day, you still win under exigency in their most cases. I mean, very rarely are cases suppressing this evidence if you had the PC. What do you think?
Yeah, I think if you can articulate the PC to search, but the Supreme Court's made it really clear with regard to search incident to arrest that cite and release, that it has to be a custodial arrest. But yes, if you can articulate, so we basically have two different things that are going on here, right? We either have probable cause to arrest, a custodial arrest, where you are searching them and send it to that, or probable cause to search plus some exigency. The exigency being they can easily leave, they can easily just remove or destroy evidence, right? But we still have to make a separate showing or separate articulation of that. So there's two different things going on. So if you can articulate the probable cause for the search with the exigency, yeah, that gets you into their pocket. But if you're just planning on citing and releasing them, I would be really, really cautious with doing a search incident to that, right?
Are you talking about the Knowles decision?
Yeah, that.
So I have a little bit different take on that. I mean, Knowles is a 1970s case out of Iowa that basically what happened was the statute allowed, essentially an Iowa statute allowed the officer to search people without taking them into custody for any arrestable offense. And basically this cop, there was probably a lot of cops out there doing it at the time because the law allowed it, but the cop was searching people for just speeding tickets. And a speeding ticket was a misdemeanor. It was technically, legally an arrestable offense. But I just don't think, to me, that case stands for the proposition that you can never have a non-custodial arrest. And so, Colorado is a good example. I don't really think that if that particular issue went before the U.S. Supreme Court, they would view it in the same eyes as Knowles, because in Colorado, you still have to have the probable cause that there's evidence of an arrestable offense on the person, even though you're not making the formal arrest. Usually you do have a full-blown custodial arrest, which means transportation, but I think those facts are a tad different in this case. What say ye, Ann?
I think it goes back to the policy for allowing the search incident to arrest, which is going to be being in close contact with them during the transport and the officer safety issue, as well as the ability to remove or destroy evidence that they have on them during that transport. So looking at the case law that does talk about search incident arrest, the courts are pretty particular about pointing out that policy reason. So if we're going to be searching people incident to a cite and release, we need to be able to articulate a similar policy. And I think that would be difficult to do. So that's why I just say be careful with that.
Yeah, I agree. Be careful. And I think at the end of the day, if you have, I still think you need exigency, right? I mean, at the end, even with what I'm trying to say, I think you still need exigency. If you don't have any exigency, if you don't articulate any exigency, then I think you're not gonna have a recognized exception. So call it whatever you want. It needs to have exigency, just like what Ann, said. And I think you have it in most of these cases, but if you don't, you're going to lose, I think. What else you got? Oh, is this helping, guys? Give us some feedback. Is this helping? Is this good stuff? Good. Good. I wish it was, some of these things were like black and white. We can just say, yes, do it. No, don't do it. But then lawyers would be out of a job, and we will never let that happen. Right, Ann? We will never let things be so simple. It's true, though. There's some truth to it. These damn lawyers, man, they love overcomplicating this stuff. Okay. What else you guys got? You got any more questions before we wrap up? I mean, we're here for, we got another like 15 minutes if you guys want to ask some questions. We love answering them. Bring them in. Come on. Okay, here we go. Fresh weed, stinky IDs got me into 10 pounds of weed. would the smell of burnt marijuana on an ID pass from a driver be enough RS to extend the stop for a K9? I have my answer on that, but I want to know, Ann, you want to go first on this, or do you want me to go first? Okay, I say no. My initial reaction is no, because all your So the question is would the smell of burnt marijuana on an ID pass from a driver be enough? No. I think all a court is going to say is that you have reason to believe that at some point they smoked marijuana. And if it's illegal in your state, that is not, there's a staleness issue there, right? PC to search and to also extend the traffic stop has to be somewhat of recent or current criminal activity. I would not detain a person and call a dog based off of that limited fact. That's me. But Ann, what do you got?
That's a really good question. I think I would tend to agree with you, Anthony, that I would want something a little bit more than just the odor of burnt marijuana on the ID. I mean, I think back to, and this is total anecdotal, but this is, oftentimes this is what judges do when they make decisions, is they think about kind of their own experience in addition to the arguments that they get. So I think about being around someone who has smoked. My mom smoked when I was growing up, and my clothes always reeked of cigarette smoke. Doesn't mean I smoked, but just meant that I was around her. So not necessarily reasonable suspicion that I had marijuana on me, or I had cigarettes on me, or I smoked, just that I'd been around it. Now, if you have, so Idaho has one of the best statutes in the world. It's called frequenting a place where marijuana is used or illegal drugs are used, and it is a misdemeanor. And so that indicia of being where illegal drugs are used, if you can articulate, I think, something a little bit more than just stench on the ID. How strong is it? Is there any other indicia coming out of that car? If it's just on the ID and not in the car itself, I think you would have a hard time articulating reasonable suspicion that there's currently use going on in the car, that is a place where it's frequented. But yeah, so I would tend to agree that just the odor on the ID isn't going to be enough. But remember, you can always call the dog in certain jurisdictions during the stop itself. So if one person is effectively working and diligently working on the mission of the stop, and your dog can get there before that enforcement action is complete to run the dog, then you get your dog alert and your enforcement actions as well. So.
Right. I mean, the vast majority of states are going to allow that. And I think Ronald's from Tennessee, so we know that's going to be allowed. The one thing I'm going to give you some advice that's very arbitrary, but I think very helpful. And this is going to be part of the bulletproof report writing class. I am teaching cops to give me 5 things about what their reasonable suspicion is. Okay. And that's what I teach. And that's what I like. And you'll be surprised. I show like videos, during this class, and we pick apart what the officer, I say, hey, what do you got? Right? What's the reasonable suspicion? Or the probable cause, but normally it's reasonable suspicion. What do you got? And this is going to be a new class, but in my experience asking these questions in the past, officers like, well, look at me like two things, 3 things. And then I show up a slide of all of the things that are there. And they're like, holy shit, you're right. There's a lot more there than I didn't even think about. That is the hidden in plain sight type of logic that I'm showing. But I'm trying to push cops. When you look at cases that uphold reasonable suspicion, oftentimes it's like 3 things, 4 things. And again, it's arbitrary. But I see value in just pushing cops to articulate more and more. Give me 5 things. And I think you're definitely in the right direction. So that's what I'm looking for here. So definitely not 1, not 2, 3 is like minimal, and I kind of want 5. Reminds me of a joke. Remember me, myself, and I was a joke. Anyway, I was gonna make a joke, but I can't even think of the movie line. But it was about 6-minute abs. You remember? It's about 6-minute abs, and it was like he had 1 minute less than everybody else, and it was very arbitrary. He goes, And anyway, you get my, maybe you know the movie I'm talking about, but that's my humor for you. It's awful. Okay. I will not quit my day job. But anyway, anything else, guys? And do you see value in that, just by the way, in just trying to push you to have like those, minimal number, like some 5 things, 4 or 5 things, if not more? Do you see value in that? I mean, I'm convinced by it. I'm personally convinced by it. I think that courts will be more persuaded to uphold what you're doing. So hopefully you guys agree and see the value in that. What else? And don't forget, okay, if you're coming up with another question, I gotta remind you, next week, okay, you can take one, all 3 days. You can just pick and choose, but you're going to be amazed. Anne is the best search and seizure instructor on planet Earth. Okay, there might have been a guy in Yugoslavia that I've heard is pretty good too. So Anne, I don't know about you can beat this guy in Yugoslavia. I heard he's pretty good, but besides that, Anne is the best. So yeah, more is better. Yep. Just kind of about that class. We know that training funds are tight right now. A lot of agencies have contacted us and said, look, COVA and protests have decimated our training budgets. We have a cop or 2 that want to attend your training. Can you invoice us later after we get our budget, renewed in October? And we're like, absolutely, not a problem. So we're here to work with you guys. If that's what you guys need too. If you need us to invoice you down the road, take the class now and invoice it after the new fiscal year. We can do that too. All right, guys. I'm not seeing any more questions coming, so I'm assuming that Egyptian magic. I'm telling you. I mean, Angela. I mean, look. You know what I mean? The product. The product speaks for itself. Right. I should be like a spokesperson for Egyptian magic. All right, guys. BlueToGold.com. Let's see you in that class next week. Okay? Let's see you in that class next week. You're welcome, guys. Thank you so much. Anne, you're the best. You're the best. And thank you for joining me. Yep. Jonathan, thank you. I mean, these are students, fellow officers, guys. Jonathan's telling you, it's worth it. And it'll save your ass. I'm telling you, more cops go to prison over illegal issues and search and seizure issues and so forth than get killed in the line of duty. This is vital. We got to know what the rules are. Okay? We got to know what the rules are. Okay? Officers are losing their job. They're getting suspended. They're getting written up because they don't know the rules of the game. You got to know the rules. Thanks, Tiana. I appreciate it. All right, guys. Have a good weekend. Yep. See you guys next week. More webinars, right? Oh, that's right. And don't forget the on-demand stuff too. On demand. Yep. All right, guys. Bye, Ann.
Bye, Anthony. See you guys later. Thanks everybody for coming out.